Hello everyone. In this video, we will talk about the salient or important provisions of the Data Privacy Act of 2012, or Republic Act number 10173. An act protecting individual personal information in information and communication systems in the government and the private sector, creating for this purpose a National Privacy Commission and for other purposes. First off, what is the right to privacy? According to Justice Brandeis of the U.S. Supreme Court, dissenting in Olmstead v. United States, the right to privacy is the right to be left alone, the most comprehensive of rights and the right most valued by civilized men. Under our own Constitution, our Bill of Rights, we have the right to privacy in the context of privacy of communications. The right to privacy is one of the core rights we enjoy as individuals. The right to privacy also includes freedom of thought, Now, what is the aspect of privacy that the Data Privacy Act is concerned about? Answer: the Data Privacy Act is concerned about informational privacy. What is informational privacy? Our court had the opportunity to define what informational privacy is, and in a number of cases, it was defined as the right to control the collection, maintenance, use, and dissemination of data about oneself. The individual's ability to control the flow of information concerning or describing him, which, however, must be overbalanced by legitimate public concerns. To deprive an individual of his power to control or determine whom to share information of his personal details would deny him of his right to his own personhood. The Data Privacy Act does not assert that the right to privacy is absolute. As always, it will be a balancing of freedoms. The Data Privacy Act, or the DPA, provides that free flow of information must be supported because we recognize that information is necessary for national development, for research. We need data-driven policies. What the DPA is simply saying is that as we benefit from the use of information, so should we be mindful of the rights of individuals to informational privacy. Now, let us proceed to the scope of the Data Privacy Act. Section 4. The DPA applies to the processing of all types of personal information and to any natural and juridical person involved in personal information processing, including those personal information controllers and processors who, although not found or established in the Philippines, use equipment that are located in the Philippines, or those who maintain an office, branch, or agency in the Philippines, subject to the immediately succeeding paragraph. Provided that the requirements of Section 5 are complied with, the Data Privacy Act does not apply to the following: information about any individual who is or was an officer or employee of a government institution that relates to the position or functions of the individual, including the fact that the individual is or was an officer or employee of the government institution, the title, business address, and office telephone number of the individual, the classification, salary range, and responsibilities of the position held by the individual, and the name of the individual on a document prepared by the individual in the course of employment with the government. Information about an individual who is or was performing service under contract for a government institution that relates to the services performed, including the terms of the contract and the name of the individual given in the course of the performance of those services. Information relating to any discretionary benefit of a financial nature, such as the granting of a license or permit given by the government to an individual. including the name of the individual and the exact nature of the benefit. Personal information processed for journalistic, artistic, literary, or research purposes. Information necessary in order to carry out the functions of public authority, which includes the processing of personal data for the performance by the independent central monetary authority and law enforcement and regulatory agencies of their constitutionally and statutorily mandated functions. Nothing in this Act shall be construed as to have amended or repealed Republic Act Number 1405, otherwise known as the Secrecy of Bank Deposits Act, Republic Act Number 6426, otherwise known as the Foreign Currency Deposit Act, and Republic Act Number 9510, otherwise known as the Credit Information System Act, CISA. Information necessary for banks and other financial institutions under the jurisdiction of the Independent Central Monetary Authority, or the BSP, to comply with Republic Act Number 9510 and Republic Act Number 916G as amended, otherwise known as the Anti-Money Laundering Act, and other applicable laws. Personal information originally collected from residents of foreign jurisdictions in accordance with the laws of those foreign jurisdictions, including any applicable data privacy laws, which is being processed in the Philippines. Section 5. Protection afforded to journalists and their sources. Nothing in this Act shall be construed as to have amended or repealed the provisions of Republic Act Number 53, which affords the publishers, editors, or duly accredited reporters of any newspaper, magazine, or periodical of general circulation protection from being compelled to reveal the source of any news report or information appearing in said publication, which was related in any confidence to such publisher, editor, or reporter.